debate in the National Assembly on 8th of October. Thereafter, members of the National Assembly took a vote and the motion was passed. On 9th of October 2024, the Speaker of the National Assembly notified the Speaker of the Senate as required by Article 150 sub-Article 2A, as read with Article 145 2A. Thus, the National Assembly followed the Constitution and the law on impeachment of the petitioner. The third and fourth respondents also opposed the petition and application through a preliminary objection that this court has no jurisdiction to hear this petition. Many of their arguments actually mirror what the other respondents have argued. On the submissions, during the hearing of the application for conservatory orders, counsel for the parties made oral arguments highlighting their respective positions over the matter. For the petitioners, Mr. Paul Mwita, senior counsel, teaming up with Mr. Macharia, Mr. Ongoya, Ms. Waigwa, I hope I got the names right, and Mr. Njomo, have urged the court to grant conservatory orders. Senior counsel puts the record straight that the petition is not a forum shopping, as the respondents have argued in their responses. Senior counsel maintains that a new cause of action arose after the National Assembly passed a resolution on impeachment motion. This was a new development that necessitated filing of this petition. Regarding the impeachment of the President or Deputy President, Mr. Mwita argues that it is a two-phase process. The first phase is in the National Assembly and the second phase in the Senate. The resolution in the National Assembly gave the court jurisdiction to do justice to the matter of impeachment of the Deputy President. According to senior counsel, when the people of Kenya enacted the Constitution, they gave this court jurisdiction to hear and determine anything said to be done in accordance with the Constitution. Senior counsel asserts that Article 23 requires the court to uphold the Bill of Rights, an authority conferred on this court, while Article 23.3 gives the court power to grant conservatory orders in appropriate cases. According to senior counsel, Article 25C is clear that the right to a fair hearing / trial cannot be limited. He maintains that the petitioner's right to a fair hearing has been violated, that public participation was not properly conducted, as the Supreme Court directed in the British American tobacco case, that this court has jurisdiction to investigate the matter since the National Assembly acted as a quasi-judicial body. In the Council's view, the 12 days provided for in Standing Order number 64 of the National Assembly Standing Orders violate Article 50 sub-Article 1 of the Constitution. Further, public participation was to take place at county headquarters until the High Court at Kerugoya directed that public participation be conducted at constituency level. The notice to that effect was issued late, and according to Counsel, that explains why the turnout was a paltry 224,000 people who took part during the exercise. Public participation was not therefore meaningful and did not comply with Article 118 of the Constitution. Mr. Mwita, senior counsel, again cited the decision in Kitaru Peter Munya and the bundle of their documents on the public as that public interest in constitutional and the constitutional values is the basis for granting a conservatory order. The resolution was transmitted to the Senate immediately, and immediately after the Senate set the process for trial in motion, posing the question, why the haste? Senior counsel again cites the decision in Joseph Enoch Aura on the minimum requirement for effective and meaningful public participation and urges the court to grant a conservatory order. Mr. Macharia, who took up after, argued that the court has jurisdiction, that the matter is not sub judice, and that the decision in Wambora case is distinguishable from the present petition, since in that case conservatory orders were issued in the middle of proceedings in the county assembly. In this case, he argues, the process concluded in the National Assembly, a fact that was also admitted by the Respondents' Council before during the hearing of petition number E522 of 2024 before Mugambi J. On sub judice, counsel argued that under the Mutunga rules, a party can approach the court in any manner and the court will have to hear him. On the ripeness, he urges that there are exceptions and relied on a U.S. decision to support the argument that where something is to happen, one does not have to wait until it happens so that there is ripeness. For the second respondent,